democracy.
Are limits on contributions to parties constitutional in the government's view?
We aren't saying that they're unconstitutional, and we also think they are distinguishable for some of the reasons I talked about. One is the distinction in the First Amendment values in this particular scheme, which is party coordinated expenditures involve joint speech, joint strategizing. The party can say no to spending on particular things if it thinks the candidate's not running the campaign right, in ways that just cutting a check don't do. And second of all, if you want to limit out contributions to parties and preserve limiting principles, we're back to the way that this law works. Unlike contribution limits, which are just, you can't spend more than $5,000 for anyone, this scheme has a welter of completely bizarre exceptions that really exacerbate any mismatch for quid pro quo.
Do you think it was constitutional before 2014?
No. But I think it was.
Ms. Harris, I'm sorry, keep going.
Oh, sorry. I think it's even more obviously unconstitutional after 2014.
Yeah.
I guess I'm still not clear on the first question that Justice Kavanaugh just asked you, which was, to the extent that we have donations being made to parties and donations being made to PACs, if the theory is not that either the party or the PAC itself is the one who's trying to bribe the candidate, if the theory is that the donor is trying to bribe the candidate through this conduit, why are parties different than PACs?
So parties are different than PACs, and I don't mean to resist the hypothetical, but I think it's important. PACs themselves can also be the source of the bribery.
They can also, fine.
Yes.
We have a lovely PAC who's not trying to bribe the candidate. We have a lovely party that's not trying to bribe the candidate. We have a malicious donor who is trying to bribe the candidate, and because of the limits on their ability to give campaign contributions directly, they would like to use a conduit. What I don't understand is what difference it makes that it's a party or a PAC in that circumstance.
Okay, so bracketing the PAC bribery hypothetical, I still think parties are different, and one of the reasons is historical, which explains the unique identity of interest between the candidate and the party that differentiates PACs. The reason why there is why the sort of party coordination is in some ways a bulwark against the donor circumvention scheme is that parties and candidates, parties exist to get the candidate elected. Parties do not want to spend money in ways that squander electability of candidates. Parties are insulated from that because they have the candidate, candidate appears on the ballot as the party's name. That is all very different, and that's part of a rich history of parties and candidates being completely entangled. It's a very different history than any other outside group. And again, that's not just for purpose of donor circumvention, in which there are real reasons why parties in particular will be reluctant to embark upon this campaign finance violating scheme, but also the fact that PACs, as Petitioner's Counsel noted, are in fact often aligned with donors in ways that don't correspond to parties. So the AFL-CIO PAC and the AFL-CIO donor example is a good one.
Thank you.